We turn our attention to overriding considerations in reorgs. An important point to consider when determining whether a reorganization exists and the consequences therefrom is that because the transaction has non-recognition as a key consequence, these consequences should be limited to only those transactions that truly deserve this special treatment. Accordingly, it is not enough to merely satisfy the statutory language for reorganization. The transaction must also satisfy several overriding requirements. These requirements include the following. 1. A plan of reorganization. 2. Business purpose. 3. Continuity of business enterprise. 4. The step transaction doctrine. And 5. Continuity of shareholder interest. We will get into more detail on each of those momentarily. Now, most of these requirements started out as or were developed as judicial doctrines, court-imposed requirements to avoid abuses where reorganization status was not warranted, notwithstanding meeting the statutory definition of the term. Whatever the history or source of the consideration, these requirements must all be satisfied in order to achieve the desired tax-free consequences that result from a reorganization. Turning to plan of reorganization. A plan of reorganization is explicitly required by sections 354 and 361. Reg 1.368-3A provides details of these requirements. The plan must be adopted by each corporate party. A statement, together with supporting detail, must be attached to the tax return of each corporation which is a party to a reorganization. The central function of the plan is to separate transactions that are part of the reorganization from those that are not. That is, the taxpayers must go on record as to what they believe is part of the reorganization. A resulting consequence is to limit the scope of a reorganization, giving the reorganization a clearly defined beginning and end. You should note, though, that for some types of reorganizations, a simple contract will suffice as a plan of reorganization. Every reorganization must have a business purpose or purposes, which such purposes must be indicated as part of the plan of reorganization. Realistically, for most acquisitive and structural reorganizations, the business purpose requirement is not that strenuous. Most combinations or restructurings can find some sufficient business purposes. Common possibilities would include attaining efficiencies in administrative overhead, synergy in bringing businesses together, etc. It should be noted, however, that the business purpose requirement for divisive reorganizations, or divisions if you will, proves more serious, more difficult to satisfy, the details of which will be explored as part of the consideration of divisive reorganizations. All tax-free reorganizations require a continuity of business enterprise. This requires the acquirer to continue the target's business or use a significant amount of the target's assets in a business. It is sufficient if one of the target's significant lines of business continues, or if the acquirer uses a significant portion of the target's business assets in a business, possibly including just intangible assets of the target, such as trademarks and goodwill. For example, it might be sufficient to sell off all the target's hard assets as long as intangibles are retained and used in a business, if these intangibles are considered to be significant. The step transaction doctrine. The first point to note here is that the step transaction doctrine is not an actual requirement. Rather, it is a doctrine that can arise in the context of reorganization transactions. Of course, it is also a doctrine that can arise in just about any transactional situation, not just reorganizations and not just corporate transactions more generally. We previously covered the step transaction doctrine in Tax 656, and I believe you considered it in Tax 627, Advanced Concepts, as well. Our present coverage of the basic doctrine will therefore be limited. It is a concept that we will repeatedly return to. The essential issue, to refresh your memory, addressed by the step transaction doctrine is whether two or more, let's call them events, are separate transactions or alternatively merely steps in a single transaction. Typically, taxpayers will engage in these two or more events, thinking or at least hoping that those events will be treated as separate transactions. But if the events are judged as being merely steps in a single transaction, the intended consequences will often change, often as a result of reconstructing the transaction as though it were one transaction, removing any redundant aspects of the transaction. We turn now to what is perhaps the most important, or at least the most substantial, overriding consideration, that of continuity of shareholder interest. The first order of business is to understand what the requirement is about. The basic concept is that the historic shareholders of the target must have some continuing interest in whatever corporation or corporations survive. The theory is that a reorganization is a tax-free transaction because it represents some minimal change in one's ownership interest. At least that's the theory. And accordingly, there must be some minimal continuation by the existing historical target shareholders. The next question becomes, what form does this continuing ownership take? What is the minimum amount of continuing ownership, and how is this minimum amount measured? Well, there are a few old landmark cases in this area, such as Minnesota Tea, Miller, the Toll versus Schofield, Cortland Specialty, but perhaps most importantly, Nelson. These and other authorities basically lay down the following guidelines. Number one, the only consideration that confers continuity is equity, that is, stock of the acquirer. Not cash or other property, not debt, not even long-term debt, such as bonds. Within equity, it appears to matter little what type of equity. Common and preferred are both acceptable for this purpose, but the type can be relevant for other purposes, which we will come back to. Number two, there is no clear standard for the minimum percentage of consideration that must be equity, but there are some important guideposts. The minimum percentage for ruling purposes assumed is 50%, and I would refer you to Rev Proc 77-37, which one assumes you could get a ruling in this context, which I suppose is its own issue. But anyway, if we follow Rev Proc 77-37, minimum percentage for ruling purposes is 50%. Now, one court, the Sixth Circuit in Miller, went as far down as 25%. But the best measure is probably found in the Supreme Court's Nelson decision, where 38% was found to be sufficient. Number three, the minimum amount of equity is measured as a percentage of what the historic shareholders of the target receive as considerations. So it's not an issue of what percentage of the acquirer stock the historic target shareholders receive. For example, if a two-person software company is acquired by Microsoft for stock that represents 1/1000th of a percent of Microsoft's outstanding stock, that satisfies the requirement as long as a certain minimum percentage of their total consideration, again, the historic target shareholders' total consideration, as long as some minimum percentage of that consideration is Microsoft stock. And again, it is the historic shareholders that this test is measured against. In essence, then, the standard requires that the historic target shareholders receive acquirer stock as some minimum percentage of the total consideration received by the historic target shareholders for their target stock. So then there is a minimum quality of consideration, equity, and a minimum quantity of this quality consideration. Now, do these standards make sense? One could argue that they create anomalies, situations where continuity perhaps should be considered to exist but doesn't satisfy the test, and situations where continuity is found but perhaps shouldn't. And note that even though the doctrine is essentially judicial, the doctrine appears fairly well entrenched at this point. Turning to problem 4, question 1, as diagrammed in the slide. X is publicly traded. Y is a closely held company owned equally by individuals A and B. Y merges into X pursuant to state law. In each of the following situations, determine whether the reorganization fails for lack of continuity of interest. All right, so the basic form of the transaction is that illustrated in the diagram. Notice that the diagram does not indicate what the consideration is. That is because that varies from one alternative to another in question 1, which we will address in the following slides. In question 1A, A and B each receive cash of 50. Clearly, the most extreme example of what the continuity of shareholder interest doctrine is intended to prevent is brought up in this example. Receiving nothing but cash represents no continuing interest, and this will not be a reorganization, even though it meets the other requirements for being a reorganization, such as being a merger, as would be described in section 368A1A. In question 1B, they each receive 1-year notes with a face and value of 50 each. This is not much better. While one might argue that being a debtor, owning short-term obligations of the acquirer connotes more of a continuing interest than mere cash, this is clearly insufficient to confer continuity. So the result is the outcome the same as 1A, no reorganization. In 1C, they each receive common stock of 26 as well as cash of 24. So they each get common stock worth 26, they each get cash of 24. Here, some consideration received by the historic target shareholders is equity of the acquirer, which is good, but is it enough? The answer is yes. It is more than 50%, which is enough even for ruling purposes. So this is a good reorganization, albeit one with boot. In question 1D, they each receive 20-year bonds with a face and fair market value of $50 each. One might argue that receiving only 20-year bonds could, perhaps depending on the circumstances, give one a significant interest in the continuing fortunes of a company, especially, for example, if the company is on shaky financial grounds. But, to be clear, this apparently does not matter. Debt does not confer continuity, and therefore the answer in 1D is that the transaction does not represent a reorganization. Again, notwithstanding that it meets the other requirements of a reorganization, such as satisfying 368A1A. Notwithstanding the argument just suggested, what is the theory for saying that debt, even long-term debt, does not represent a continuing interest? Well, perhaps the biggest point is that at the end of the day, or in this case the 20 years, as the case may be, the target shareholders end up with the predefined amount of cash indicated by the debt instrument. Their risk, their interest in having the company do well in the future is reduced to whether the debt can be repaid. And from this perspective, even long-term debt is very different from equity. In question 1E, A and B each receive preferred stock worth 12, and they each get cash of 38. As previously mentioned, it would appear that the type of equity is not relevant to the issue of continuity, and so non-voting preferred is comparable to voting common for this purpose. One could again question whether this always makes sense, but that does appear to be the state of the law. The question then becomes, is there enough equity? These facts suggest that equity represents 24% of the total consideration received by historic target shareholders. Presumably, this is insufficient, and therefore there is no reorg in 1E. In 1F, they each receive participating preferred worth $20, and they each get cash of $30. Well, the fact that the preferred is participating probably adds little or nothing to the resolution of the continuity issue. The real issue is, again, whether the amount of equity is sufficient. Here, equity represents 40% of the total consideration received by the historic target shareholders, and therefore, while not enough for ruling purposes, this amount exceeds that received in the Supreme Court's Nelson case. This strongly suggests that there is sufficient equity, and therefore a reorganization exists. Now, one might ask, if the Supreme Court found 38% sufficient, does this not automatically dictate that enough equity continuity exists? The safest approach is that it is not a per se indication. One way of explaining the reasoning is that the Supreme Court is an appellate court, not a trial court, and a determination of sufficient continuity of shareholder interest is largely a determination of fact, a determination best left to the trial court, for example, the tax court. Another perspective is that the determination should be based on all the facts and circumstances, and those facts and circumstances will naturally vary from case to case. Nonetheless, the Nelson case provides a substantial authority on this issue, and so the requirement is almost certainly satisfied in the present question. In question 1G, same as C, except that A and B had bank loans to finance their Y stock purchases of $40 each. X assumes these liabilities as part of the merger. Well, for purposes of measuring continuity of shareholder interest, having the acquirer assume shareholder liabilities is the equivalent of the shareholder receiving cash and paying off the liability. And so each shareholder is treated as, in essence, receiving cash of 64 and stock worth 26. 26 divided by 90, which is the total of the consideration received by each shareholder. Cash of 64 and stock of 26. 26 divided by 90 is 29%. This level puts the continuity of interest issue in a gray area, probably not sufficient, but not free from doubt. The Miller case I mentioned before is one favorable case in this regard. Question 2A is illustrated in the diagram on the slide. In 2A, instead of Y merging into X, Y merges into X's wholly owned subsidiary Z. A and B each receive stock of X worth 30 and stock of Z worth 10, as well as each receiving cash of 10. And so again, this is illustrated in this diagram. What happens? In answer to question 2A, given that consideration received by target shareholders must include some minimum amount of stock, another question which arises is what stock? Or put in it another way, stock of which company? More particularly, can you include stock of only the acquirer, or can you also include stock of a company related to the acquirer, particularly stock of the parent of the acquirer? The facts of example 2 bring up this particular issue. In 2A, stock of the acquirer Z represents only 20% of the total consideration, presumably not enough. But if one could include the stock of Z's parent X, the requirement would be easily satisfied here. But we cannot include the stock of X. Why not? There is a case that tells us so, Groman. The Groman doctrine basically tells us that only stock of the acquirer confers continuity, not stock of its parents. So the transaction in 2A is not a reorganization. The Groman Doctrine is backed up by the Bashford case. In question 2B, same as A, except that they each receive X stock worth 40 and cash worth 10. Well, here, X, the parent, has its stock as 80% of the consideration. Based on the lesson offered by the Groman Doctrine, this would seem an even worse situation, with no continuity. And yet, this transaction is a reorganization. So again, to be clear, 2A is not a reorganization. Question 2B is a reorganization. Why? How can this be true? Well, it's because there is a specific statutory override. Section 368A2D blesses the facts of question 2B. So what do we learn here about the Groman Doctrine? Well, the doctrine continues to exist and continues to stand for the general proposition that only stock of the acquirer, not stock of, for example, the acquirer's parent, will confer continuity. But there are specific statutory overrides where stock of the parent is acceptable and indeed necessary. Basically, every triangular reorganization represents such an override. And we will consider a number of triangular reorganizations in this course. And again, the point then is that the statute allows stock of the parent in order to have a triangular reorg, and that stock overrides the Groman Doctrine. Question 3, as again illustrated in the diagram on the slide, A is a 45% shareholder of Y, while B is a 55% shareholder. Pursuant to a merger of Y into X, A receives shares of X common worth 45, while B receives cash of 55. The basic issue in this example is this: is it enough for the target shareholders to receive, in the aggregate, some minimum percentage of their consideration in the form of stock, or is there a further requirement that some minimum number of historic shareholders receive stock? What one will notice in example 3 is that the majority shareholder received nothing but cash. Is this going to present a problem? Well, while there is not much that discusses this issue, the apparent answer is that the issue is not an issue. So, as long as the historic shareholders receive in the aggregate some minimum percentage of their consideration in the form of stock, they will satisfy the continuity of shareholder interest requirement. Here, 45% of their consideration was stock, and under the Nelson case, that is enough. So this represents a good reorganization. Question 4 has facts that are rather long. I'm not going to read them. I will leave that to your own devices. I would also note that it's not, as it turns out, for reasons I will discuss, it's really not critical that there are differences between the various alternatives to question 4, 4A, 4B, 4C, 1 little I, 2 little I, etc. Again, for reasons that I will bring up. What is the issue in question 4? Well, the issue being raised is how long must the target historic shareholders own their acquirer stock? Initially, the target shareholders received only stock, so clearly they would satisfy the requirement at that juncture. But then, target shareholders representing 80% of the target stock sell their acquirer stock for cash. If one measures the continuity of shareholder interest requirement at the time of the merger, the requirement is clearly satisfied. But if one measures the test long enough after the stock sales, the requirement is almost certainly not satisfied. In essence, then, the question becomes, does the step transaction doctrine apply treating the merger and subsequent stock sales as merely separate steps in one transaction. If one were to theoretically apply the traditional step transaction doctrine tests to the alternatives in question 4, would a step transaction be found to exist, theoretically? It would seem intuitively that the more time that passes, the less likely a step transaction will be found to exist. 2 years is a lot longer than 10 days, yet the courts seem to give little, if any, weight to the actual amount of time that passes. At least they give little weight to time when it comes to writing their opinions. One cannot help but think that, legal theory notwithstanding, the amount of time that passes does weigh heavy in their decisions. If time is not the critical factor, one might ask what factor or factors are critical. Well, this is mostly now just a theoretical discussion. Why is that? Because Regulation 1.368-1E makes it mostly theoretical. This regulation indicates that a subsequent sale of the acquirer's stock by the target shareholders does not generally break continuity. Now, the regulation leaves open the possibility of applying this doctrine on a facts and circumstances basis, and the critical issue for applying the doctrine appears to be whether the acquirer directly or indirectly provided the funding for the sale. And so, absent that fact, where the acquirer directly or indirectly provided the funding for the stock sale, the continuity of interest requirement will be satisfied even though there is a subsequent sale of stock. A final issue that arises with regard to the continuity of shareholder interest requirement is how to treat contingent stock considerations. For example, if the historic shareholders receive some stock, some cash or other boot, plus the right to receive additional stock contingent on some event or events in the future. For example, a common possibility is that the acquired company meets predefined earnings benchmarks. How will these contingent stock rights be viewed, as additional stock or as boot? Well, while there is no clear answer, presumably the contingent stock rights will be viewed as additional stock. There may be limits to how much contingent stock can be used in a tax-free reorganization, but this issue presumably comes up in other contexts, not so much in the context of the continuity of shareholder interest requirement.